All right, hi everybody. I'm here with KPRC legal analyst Brian Wice. We're going to talk about the basics of a grand jury, how it works, how it arrives at decisions, especially in light of what's going on right now with the Hernandez case. So, Brian, first of all, grand jury, it's 12 people, but unlike a criminal jury, it does not have to be a unanimous decision. Is that correct?
That's true, Robert. 9 of 12 required to return what's called a true bill of indictment, which means the case is then transferred to a Harris County District Court for trial. But what's also important is that unlike trial juries who deal in proof beyond a reasonable doubt, grand jurors are only concerned with whether there's probable cause. That is, whether it's more likely than not that a crime was committed and the defendant committed it.
So essentially, a grand jury is deciding whether there is enough evidence to warrant a full criminal trial.
Absolutely. It's a mini trial, but really that may also be kind of a misnomer because hearsay testimony is largely admissible, which is not at a trial. There's little, if any, cross-examination. Defense attorneys are not permitted in, and the citizen accused or the suspect, unlike a trial, doesn't have the right to be present.
Okay, so the district attorney's office can present what it wants, and the defense or the person who is potentially the target of that investigation really doesn't have any say in what the prosecution presents to a grand jury and can't really refute anything or does not have the opportunity to refute anything.
That's correct, although really good lawyers will put together what we call grand jury packets. If there's a case where you think that you've got a fighting chance of having a no bill returned, you as a defense attorney can put together information, a packet that is then submitted to the grand jury that they can consider in determining whether probable cause exists. And really good lawyers have had really good success in convincing juries in borderline cases to return no bills as opposed to true bills.
Okay, let's do this again. A no bill means they don't think there's enough evidence to warrant a criminal trial or to support the charge that's being placed on a person. A true bill means, yes, there is enough to keep that charge in place and go to a trial, correct?
Absolutely, that is correct.
And one other difference I noticed between grand juries and juries is grand jurors can ask questions back and forth. There's a lot of open discussion, whereas we see in criminal trials, jurors, they have to be very silent. If they have any questions, they must be done in writing, presented to the judge only, no discussion in the courtroom. But a grand jury, they can talk, they can ask questions back and forth, they can subpoena. Pretty much they can decide, you know what, we want to hear from that person. Go out and get us that person without that person being signed up as a witness in the first place. Is that correct?
You're right. And as somebody who served on a grand jury back in the summer of '42, and as somebody who is presented to a grand jury as a special prosecutor, I'm aware more now than ever that a grand jury presentation is more of a free-form exercise. It's whatever the grand jury wants to hear and whatever it is they want to see before they ultimately make a determination of whether probable cause exists. And you make a great point about asking questions. That's the essence of a grand jury presentation in large part. The Court of Criminal Appeals held, on the other hand, that juries cannot submit written questions during trial. The only time that juries can ask questions is after the evidence is concluded, submitted through the bailiff, approved by the court, and only in very limited situations.
So basically, a criminal trial jury can only ask questions when they're trying to decide guilt or innocence after the trial has essentially concluded, that portion of the trial is concluded. Grand jury can ask whatever it wants at any time that it wants.
Absolutely.
And the other thing is, too, the one thing that we've said is a lot of times you don't get a lot of information about what's presented at a grand jury, even who's testified before a grand jury, because by law, grand jury proceedings are secret. That's correct. And if you talk about it, you not only can get in legal trouble, you could possibly face criminal charges as well.
You can be held in contempt. You can face serious legal trouble. That's because grand juries go all the way back to common law England, where the king could pretty much put a case on anybody if he wanted to. The grand jury was designed to be the conscience of the community, to be the filter through which citizens ultimately were protected from just being snatched up in the middle of the night for almost anything. And because so many grand jury proceedings ultimately result in no bills, or the fact that investigations you and I may never even know about, secrecy is the hallmark. Secrecy is the currency of the realm, and it's there for a reason.
Okay, and that's why you don't even know who testifies sometimes. I mean, we can see them, we can see who goes in, but we really don't know if they've actually been called to testify. They may just be asked to wait outside in case the grand jury wants to hear from them.
Not only that, but this is a critical point. Who can be inside the grand jury during its deliberation is set by statute. The only people who can be in there, other than the 12 grand jurors, are a court reporter, if necessary, the prosecutor who is presenting, and a witness or witnesses. Other than that, and that's usually law enforcement, it's rare that we hear from civilians necessarily, but it's because the attendance is limited that we can be sure that the process is as secret as it possibly can be, and yet fair at the same time.
Okay, and last point on this. Unlike a unlike a criminal trial, where a jury will have that one case, that is the one case they hear from beginning to end, guilty, sentence, grand juries serve for long periods of time and hear multiple cases.
When I served, we served twice a week for 3 months at a time. Now grand juries continue to sit twice a week, but they sit for 6-month terms, and they've got bunches and bunches of cases on their agenda. I can assure you that whatever grand jury Kim Ogg decided to send this to, they've got a lot on their plate. And what's worthy of mention for our viewers is that the typical case is presented within 2 or 3 minutes. That's it. It's a grand jury prosecutor reading from an offense report, essentially saying, Robert Arnold rented a car from Avis. He didn't bring it back. A certified letter was sent. All those in favor of a true bill, raise your hands. And it's the same thing with lab results in a crack case or anything of that nature. These are the kinds of cases that take the most time because, quite frankly, they're the most complicated and the most important.
Okay, great. Thanks, Brian. And thank you all for watching.